There are millions of acres of opportunity out there. They belong to you. Every day, decisions are being made that affect your land, your water, your wildlife. You should know about them. This is your mountain. Hey everybody, welcome back for another episode of the Your Mountain podcast. I'm your host, David Wilms, and I've got, as per the
How
usual,
you doing, Dave?
Nephi
Happy
Cole
lunchtime.
sitting right next to me, shoulder to shoulder.
Yes,
I'm doing
something.
well. It is kind of lunchtime,
Well,
isn't
do
it?
what you can.
We either do it at night or over lunch, right? You do it when you can, right? And as is becoming the usual, unfortunately, Mike McGrady isn't able to join us today. But we know he's here in spirit, and I know he really would like to be part of this.
Let's just be honest. This is anybody following the NBA playoffs. This is better. It's Christmas time in a bad way.
There's just as much drama, and this is really like game one. We just kind of finished game one in a multi-game.
We got a battle,
court
but the
hearing
war is
series
still
here.
continue.
It is going to continue. So you're probably wondering what we're talking about. And first of all, let me say this. We promise we're going to start having guests on again. It's been a few weeks since we've had guests, and we actually were planning on having a guest this week. But then something happened, and we felt like this was too important, and we needed to address this immediately. And so, I mean, there's a U.S. Supreme Court decision that came down. Well, you're hearing this on a Tuesday, which means it came out yesterday, but we're recording this within hours of the court releasing its opinion. And if you remember, with the Your Mountain podcast, back on episode 29, we did an episode, and this would have been in around November of 2018, early November, I think. Maybe even October of 2018, we did an episode talking about this case that was about to be argued before the United States Supreme Court called Herrera v. Wyoming. And this case involves the interpretation of a tribal treaty right, specifically related to the Crow tribe in south central Montana. And specifically an interpretation of language in that treaty about what their off-reservation treaty rights
Nutshell,
are.
super fast.
Do they
off-reservation treaty right?
So at the time, 1868, this treaty was entered. The Fort Laramie Treaty was entered into. Right in 1868, there was language in this treaty that said the tribe would have the right to hunt game off reservation, so outside of the bound. They forever have the ability to hunt within the boundaries of the reservation. So this was okay. You have the boundaries of the reservation, but the tribe was to have the ability to hunt outside of those boundaries so long as game persisted on unoccupied lands of the United States. And also, maybe of lesser import, but also so long as the tribe and the United States are at peace with each other, right? But the two big pieces here are so long as game persisted and on the unoccupied lands of the United States. Right.
I do want to say
let's go back really quick.
Since we did the podcast, because a bunch of different people have done articles on it and other podcasts on it. So for all of you listeners who are about to write an article based on the things we're about to say, thank you very much. Please credit us.
That's right. Well, I've actually received a number of phone calls. That's right. Well, and I've actually received a number of phone calls today from people wanting to have discussions about this and do reports about.
Just don't pretend like we don't exist after you
decision.
talk to us on the phone.
What does this decision mean?
Really? Please?
We're here, right? We enjoy being the source of information. We enjoy diving into the.
At least send a T-shirt or something.
With the analysis.
Or buy one. Go ahead.
But so here's the deal. Yeah, so here's the deal. Let's go back in time a little bit, and by back in time I mean let's just go back a few years. Where did this case come from? Now, go back to episode 29. Listen to that episode of the Your Mountain podcast to get the full download of all the facts of this case. But in a nutshell, this was a case that that came about because a Crow tribe member came into Wyoming with a number of his friends and killed a number of elk out of season in the Bighorn Mountains of Wyoming, which is in north central Wyoming, just south of the Montana border, just south of the tribal boundary, mile and a half into Wyoming. Killed a number of elk. Don't need any of the surrounding facts. You can get all that in our other podcast. But that's what happened. Ultimately, the Wyoming Game and Fish Department found out about this, cited Mr. Cliven Herrera for this, along with a couple of other tribal members. And those other tribal members paid their fine and moved on. Right? Cliven Herrera took the case to trial and asserted a treaty right. Said, this 1868 right protects my ability to hunt.
I'm good. What I just did is great.
Off reservation, right? I'm good. I can do it.
Yep.
I'm
the
not
fact that I went
bounded
out of season
by
and
the
smoked
laws
these
of the
elk
state
in
of
Wyoming,
Wyoming.
not a big deal. Yep.
Because I'm guided by
I don't have to
different
obey
legal
your
document,
rules.
not the laws of the Wyoming Game and Fish Department, because I have a treaty that sets the bounds of mine. Right? So that was the case, and that started in circuit court in Wyoming and went up through Wyoming Supreme Court, and ultimately, the determination there was that there was no longer a treaty right, that the tribal treaty right expired upon statehood, the U.S. granting statehood. At that point, the tribal treaty right ceased to exist. That's what the Wyoming courts said. And so they upheld the conviction of Mr. Herrera for taking an elk out of season. Right. Mr. Herrera appealed to the United States Supreme Court, who took up the case. And there were briefings and arguments in early January on this, and the decision that came down on May 20th of 2019.
Yes.
Yesterday.
Yep.
Today as we're recording, yesterday as you're listening, right? But it came out on May 20th, 2019. The decision said this. First of all, it said, yes, there is a treaty right. Said that the granting of statehood did not invalidate that treaty right. And they cited other case law, to support that contention, right? And we're not going to go into the nuances of all of those other laws. We're going to keep this pretty high level. But what we're going to tell you is that the court said, yes, there is a valid treaty right
lands of
that
the US.
exists today
Bang.
to hunt.
Yep.
You got it. To hunt on the unoccupied lands of the United States. Right. Now, they identified one other piece here. Right. So the court then had to decide, okay, that a treaty right existed, but is there a such thing still as unoccupied lands? The state of Wyoming had made an argument that at the time Congress created the Bighorn National Forest, that act of Congress created occupancy of those federal lands. And in addition to that, the state of Wyoming also said, hey, not only did that act create occupancy, but other actions that took place on those lands showed occupancy. Things like logging and mining were two things that were specifically brought up. And having a regulatory scheme for hunting created occupancy over these. This is Wyoming's
the Bighorn
argument to
National
the
Forest
Supreme Court.
now does not automatically make it occupied. In fact, Sotomayor said, "Oh, sorry, backing up."
Well, so you just got ahead. So I said that was the case. I mean that those are the arguments that Wyoming was making, right? And so we were teeing this up as saying, okay, so Wyoming's argument was that there were no unoccupied lands left. That space had been filled. All of those federal lands, even though they're still federal lands, are occupied.
Because
but the court disagreed with
Sotomayor
Wyoming's
said
argument.
the court holds that the Bighorn
Why?
National Forest is not categorically occupied. Not all the areas within the forest are unoccupied. So They said it's not occupied, but not all the areas are unoccupied. So they basically, and we'll get to this. What does it mean to remand? But they just basically said,
we
like,
got to get to a few things before we even get there.
The fact that it is now that it has been declared a national forest doesn't make it de facto occupied. But they still said there are both unoccupied and occupied areas in there. But the Supreme Court said, we're not even touching that. Okay.
Yeah, but before we get to that, we got to talk. The Supreme Court. First of all, the Supreme Court made a determination that there could be lands that are unoccupied, right? They said you can't say these are de facto occupied, which means there could be some unoccupied. And they said they were, as part of their analysis for saying why Wyoming's position was not correct. They were saying you have to go back and interpret a treaty based on the language and the understanding of the terms of that treaty at the time that it was negotiated. And that's basic statutory construction, treaty construction. And when I say construction, I mean that's Law 101. You start with the plain meaning, the language, what do the words on the paper mean?
In the context of that
mean
moment.
To the people that wrote them at the time of that moment. And what the court said when they were looking at this said, in that moment, what the Crow tribe believed occupied meant was a lack of settlement. And in fact, the creation of the Bighorn National Forest bolsters the tribal argument of a lack of settlement because it's by definition removing land from being able to be settled in the context that they knew it then, as in putting in farms and ranches and building homes. Right?
Carving it out as a reserve for national
what the court
forest.
said here is
It basically makes it, yes.
means it
Very
cannot be
fascinating.
settled, right? And so that's one of the arguments that the majority made in this case, right? That the majority's opinion lays out in this case. Okay, so we have that laid out, that okay, we know there's a tribal right, and we know that there is a such thing as still today as unoccupied
I'm gonna
federal
get ahead
lands.
of us, but I think when I said very amazing, I want people to understand why I say this is so interesting, because so many of us, and there's a big contingent today, where do we like to hunt? What is that priority? Public lands, right? So you're looking at those national forests, BLM. So these areas that have been reserved for all of us to be able to go do those things on, it's those areas we're talking about.
Right. Now, one thing that I found interesting about this case is the area that the tribe in 1868, the area that the tribe historically hunted,
As was
that
I.
would have been considered and I'm using
A lot
air
of
quotes here,
there's
hunting
four,
district
there's two sets of
in
air quotes at this
1868.
table right
1868. Yeah, because it was an area far greater than the Bighorn National Forest. Yet, throughout this case, that's all we talk about is the Bighorn National Forest. But you could make the argument that now that the court has said there's a such thing
It
as
applies
unoccupied
everywhere
lands
else.
in the national forest, that it could apply to
Which is my
BLM.
favorite.
It could
I like
apply to
that
national
idea.
parks,
I do.
national
I
monuments,
do.
U.S.
It's the
Fish and
most-
Wildlife
I
Service.
mean,
You
it
like
is
the
the-
national parks one. I know you do.
It's the most entertaining one to
I mean, it's the most
spin your wheels on in your
extreme,
head.
and it's probably... Yeah, like as people
watching
are sitting
somebody
around at Old Faithful,
arrow it.
watching the guys
Arrow it.
erupt,
I
and
mean,
watching a bison
that
walk
is-
by, and then boom,
That's
you know,
natural.
just pop. Yeah, it
Probably
is
not
that going
in
to happen?
Yellowstone.
I really don't know. I don't think so. Just because of the way the organic act of Yellowstone is written, so the law creating Yellowstone actually it explicitly prohibits
Boo.
hunting
Boo,
by
boo organic
everybody, and so I think probably you're not going to see hunting in Yellowstone National Park as a result of this. But I do think there's a lot more. We have a lot more to
Act
come,
one.
which is why at the very beginning of this we said, we're in
First chapter.
game 1, act 1, whatever you want to call it, first inning. There's a lot to go, because here's what happened. So the Supreme Court made this very narrow determination of recognizing the existence of a tribal right. and saying that there is a possibility that there could be some unoccupied lands for which that right could be exercised upon. But it did not determine the extent of that right or any limitations of that right. And what I mean by that is it did not say, is this right good only on national forest? How much of the national forest? Could it be on BLM as well? How much of the BLM? Does it apply equally to all tribal members? Does it have to fit within a scheme, a management scheme set up by the state to exercise? What's the scope of the tribal right? So there are things that still have to be decided. So what the court did is it remanded this case back to the Wyoming trial court.
Yep.
I mean,
so
this
hot
is going
potato,
back
get the potato
to
tossed
Sheridan
right
County,
back down from the Supreme
Wyoming.
Court.
Like this thing goes from the Supreme Court of the United States, and they say we're sending this all the way back
Which
to
is
the
pretty
trial
cool.
court in Sheridan County, Wyoming.
That means if you
for
go
further
watch that
proceedings.
case play out in
So
Sheridan,
what does that
which you
mean?
can also visit the new Weatherby factory. Okay, go ahead. Sorry. No, I love
the
those
amount of times
guys,
you
though.
plug. Well, I guess you haven't really plugged Weatherby that much, but I'm like, yeah, I know you do. You love anybody that makes guns or ammunition or anything like that. And why not?
the cool
Why not?
ones.
We all do, right?
Which they all are.
Yeah.
Okay, go ahead.
Yeah. But that's a little off topic. So here we are. So I want to give you a picture of what happens next, because this morning I was seeing news reports, I was getting phone calls, I was getting emails, and there's this sky is falling message. I was getting messages from folks saying the North American model is over, it's dead. People are going to be these tribal members are going to be able to go out and hunt whenever they want, wherever they want, for as much as they
Mad Max
want.
nature of
because of this,
like what you could
this
like
case.
stir up in your brain right now, like it is Mad Max beyond. Like that's more entertaining for us as human beings. So like stick that in your head than the boring reality that we may be getting.
But let's
First,
talk about that
let me
boring
do- let me
reality,
Mad
because the
Max in my
boring
head a little
reality
bit.
is
Okay, and I'm ready for it.
dun
Okay.
dun dun. All right, so the boring reality. So here's where we are. We are a long ways away from having any resolution on this issue.
And this, ladies and
That's-
gentlemen, is why
I want that to be
is why
crystal
law
clear up
school is
front.
such a great
We are
investment.
a long ways away.
It's never
Because
over.
you can just make money off of one case for a decade. It's not. So what happens now? It goes back to the trial court in Wyoming, and they're going to have what are called evidentiary hearings on this. They're going to go out, and the state of Wyoming is going to have to produce a whole bunch of evidence to be able to try and establish what it's going to make an argument.
Yep.
The state's going to make an argument of what occupancy is, right? They're going to make this argument, and maybe they're going to make the argument that the entire Bighorn National Forest is occupied in the terms that the tribe would have understood in 1868 as occupancy, as in settled. I don't know how they're going to do that. That might be something an argument they make, right? They're going to go out and have to spend a bunch of time pulling together evidence here. There might be other avenues of this case that develop, like part of this
Which
case
takes you
was
to the
hunting
conservation
game so
necessity.
long as game
Oh.
persists. Not quite.
Oh, yeah,
That's
yeah.
the third piece.
Yeah.
So there's another piece that the Supreme Court
I know
doesn't
where you're going.
address. It doesn't address. But there is a piece here that might, I don't know if it's going to come up, but it might come up. The tribe had a right so long as game persists. Well, in the Bighorn National
They were
Forest, one thing we know
extirpated.
is that elk ceased
They were
to
gone.
persist at some
and so,
point.
and which
They
when
were
we talked about,
extirpated
go
from
back to
bighorns,
episode
right.
29 when we talked about it. That was, you can see in some of the letters and discussion at the times, it's like people were like, this was almost a throwaway thing you were giving because like, everything's going to be extirpated from there anyway. There will be nothing to hunt. This won't be an issue. Well, yeah, you just figured you
That
were
was
going to
common with a lot of treaties
the
with
slaughter of
tribes
buffalo
around
and
the
wild
West.
game as a control method, unfortunately. But guess what? We've come back from that.
Right. Well, and we came back from it as in it was the state of Wyoming that, through partnerships, reintroduced elk into the bighorns. So the question would be, once they
Was it-
stopped, once that game stopped
Was it
persisting,
extinguished
did
when there
that
quit being
piece
elk
of
there?
the right go
Yep.
away? Now, was it
Excuse me.
right? Or or not. That might be something that comes up. And we're not talking specific to elk. There are a whole host of other species, but maybe for the purposes of elk, that might be an argument that is made. So those all have to be played out through evidentiary hearings. And then there's a third piece of, okay, so there's a tribal right. Now assume for the sake of argument that a trial court determines there is some level of unoccupied land, that there's some of the forest is unoccupied and could be, hunting by tribes could be exercised on this. There's a doctrine known as the doctrine of conservation necessity, and it's been recognized by courts. Think of it this way. The idea behind the doctrine of conservation necessity is really, you could lay it out this way. We have over 320 million people in the United States. If we didn't have a regulated system of wildlife management, that is, if we didn't have a licensed system that managed
you, Dave,
the take
would be out hunting elk every day. Yeah, I mean, this is zero doubt.
Until they were gone.
Like, right. Probably with you.
Right. I mean, but that's the idea is, because of the way the landscape is fragmented and because of the amount of pressure on the resource, that we have to have some kind of regulatory construct, and we can't have a system where we have no regulation and limitless hunting. And so conservation necessity would say, the doctrine of conservation necessity would say, yes, there is a tribal right. Historically, that tribal right would have been limitless, that it would have been, you could hunt at any time for any species in any amount as was provided under the treaty. But times have changed enough that in order to make sure that we still have elk in the numbers that we want to see elk for current and future generations, you have to quantify what that right is and then plug that into the state
I think
regulatory
this is the opportunity
framework.
to now incorporate this decision into the North American model of conservation.
That's exactly right. So, but we have at least
First,
one, maybe two
about
steps
these
to go
other
before we
things.
even get to that piece of this. First, we have to talk about what is unoccupied land. And here's what I can tell you. Whatever the trial court decides in Wyoming is not going to be the final say on what
you think that
unoccupied
people would
land is
take
in this
this
case.
back to the
I have a
Supreme Court?
hunch. Just call it a hunch. I have a hunch that the Supreme Court hasn't seen this case for the last time, and it may see it, 2 more times before this whole thing is resolved, because there are just a couple of issues that have to be resolved. But we have to determine first: is there, what is unoccupied land? How much land is unoccupied? Is there a test for determining occupancy? Right, and then we have to say, okay. Now, is there a limit on the right? Besides just hunting on unoccupied lands, is there a further limit on that right, as in this doctrine of conservation necessity? And if there is, what is that? And my guess is there will be disagreement about what that should be. And so that's why I say I think we've seen the first round of at least a 3-round heavyweight bout. Is that about the fourth
works.
sports analogy?
You don't have
We've done baseball,
just run with
basketball,
it.
boxing.
I love.
We're at the starting gate. Now we're
I
talking
love a
horse
couple
racing or
quotes from
car
this
racing. I don't know
case.
what we're.
The first is the judgment of the Wyoming District Court of the 4th Judicial District, Sheridan County, is vacated. The case is remanded for further proceedings not inconsistent with this opinion. It is so ordered. I know. I just like that.
That's pretty much how every Supreme Court case ends.
Absolutely. And then my other one
you'd love
that I
reading
really
every
liked
Supreme
is
Court
because
case.
we talked about this. I loved what Alito said in his dissent when he said, "Thus, the court's decision to plow ahead on the treaty interpretation issue is hard to understand, and its discourse on the issue is likely, in the end, to be so much wasted ink."
Yeah, and what you've done by saying that line is you've opened up a potential 15,
just think
20-minute rabbit hole that I'm not going to go down because there's a really hyper-technical legal argument being made in this case that Alito in his dissent was talking about, and why we could go through the mechanics of recognizing a right, but ultimately that right will never be
because of these other things that
exercised.
need
There
to
won't be an
be
ability
that
to
need to be
actually
addressed
exercise
first.
that right because of some of these. Not even. I mean, it's
we
really
won't talk
this
about
legal
reps and all those
nuance
things,
around
but
this
yes,
Repsis
absolutely.
case that I don't even want
You know,
to
there's
go
this
into.
is again, in my mind, it's just an interesting way of saying like, hey, but we got a lot further to go, and unwinding for those people that are freaking out about this. We got a long ways to go. So if you just read this decision based on this treaty interpretation, we got a long ways to go before we actually know how this plays out in the end. And yes.
That's the big takeaway. The other piece we didn't mention here is this was not a slam dunk. This case was decided 5-4, with Justice Gorsuch being really the swing vote. If you were to break out the court, 9 justices, and there's a traditionally conservative wing of the court and a traditionally liberal wing of the court, and your traditionally conservative wing of the court sided with the state of Wyoming in this, and your consistently or traditionally liberal wing sided with the tribes, and then Gorsuch, who would normally be in that conservative wing, sided with the tribes.
Consistent
and that's
with his judicial.
If you go back to when Gorsuch was on the 10th Circuit Court of Appeals,
he tends to side this way on these things.
Past practice for him.
Interesting
he's,
things. We all,
he's a very pro-tribe justice.
No, not to toot our own horns.
And we're not
on this,
anti-tribe. I
think when we all looked at the makeup of the court, I know that I was telling people last year, it's like, this is how it's going to shake out. And this is the guy whose decision is going to matter. And it's exactly what we thought. Yeah.
We had a pretty good sense this is exactly how it was going to come down. And
congratulations to us.
In some ways,
yeah.
That's,
oh man, you're
let's shake each other's hands. I'm shaking hands right now. Yeah.
Yes, here in this
Great
arena
job.
of
Good
two
job.
individuals, we are the
Nice
smartest
work.
people in this room.
Yeah.
There's a dog on that
That's
couch
right.
over there, but he's not very smart.
Smartest people on this podcast right now. Yeah.
Yeah. Oh. He's an
Yeah,
Australian
he's
Shepherd,
young.
which, by the way, has nothing to
he's
do with
learning.
Australia. So it's another podcast.
No. Anyway, the big takeaway from this case is don't go out there saying the sky's falling. Don't go out there saying the North American model has been uprooted, turned on its head, doesn't exist anymore, just blown up. We're a long ways from that, and it's hard to find examples where this case isn't unique to Wyoming. The fact of the matter is, most Western states that have tribes that have had treaties have had to figure out a way to incorporate those tribal rights into their state management scheme. Wyoming just hasn't had to do that yet. And it looks like they probably will now have to figure out how to do that. But it's not like it's breaking new ground in a lot of ways. It's been done other places. It can be done here in a way that can be effective.
But it could create
and
some
work.
interesting wrinkles in other states and other treaties with similar language as people seek to how they interpret these things, potentially.
I think there's only one, maybe two treaties that have the exact same language as this. So there's potential wrinkles for a couple of other treaties out there in several other states. I mean, it would potentially cover a lot of other states. Yeah, you're right. How this pans out could have implications for other states and how they do their management. And it is worth saying that even though we're sitting here saying the sky's not falling, at least not yet, for the North American model or for hunters and anglers, you do have to be forward thinking and think, okay, what happens if, and you run your hypothetical of what happens if the ultimate decision is there is a tribal right, there are unoccupied lands, and the tribe can hunt those unoccupied lands, even bounded by the doctrine of conservation necessity. They'll be allocated some licenses that now, at that point, would no longer go to residents or other non-residents that would apply. That allocation would come out of that larger formula for management to make sure that our herd levels stay at or above objective. Right.
And
so there are implications on the hunting
given
community.
Areas. We talked about
sure.
this, unoccupied lands of the U.S. and areas where you have a whole lot of these big public land, big public land hunting. It's worth thinking about. And as you said, though, the sky is not falling. And so just like the sky is not falling, anybody that did think that the North American model was done for, so you're about to go get your Mad Max truck and a bunch of your buddies and just go blazing through the great wide open, don't do that. You're gonna get ticketed still. So please,
and maybe
the laws still exist for everyone listening to this. Don't go nuts.
And maybe we should take partial blame for that sky is falling approach, because we did call that episode 29. We did call it how an 1868
it still
treaty
applies.
could turn the North American model on its head.
That title,
right.
I stand by.
It was a little hyperbolic,
it still
perhaps,
applies,
right?
As does the Mad Max analogy, which, though
No,
far-fetched, is much more entertaining than going to the Supreme Court 2 more times.
It absolutely could still apply.
Oh,
right?
I love this.
Let's talk about another hypothetical
Please
outcome.
do.
Because, another hypothetical outcome is that there is a tribal right, there are unoccupied lands, and those unoccupied lands could become the Bighorn National Forest, the Thunder Basin National Grassland, the BLM in all of northern Wyoming and parts of Montana and the Dakotas, right?
All right.
All of that. I can't go that far. But let's go with at least that picture, right? And a court decides, you know what? The doctrine of necessity doesn't apply here. Of conservation necessity doesn't apply here. And so there's really a limitless right for the tribe to hunt those lands whenever they want, with no seasons, no limits, that sort of thing. That's a hypothetical, I'm going to put in brackets here, but unlikely, but a hypothetical outcome that would then make our title of that episode 29 much less hyperbolic.
Tune in next time. You can sort our credits. David Wilms. David Wilms, Esquire. How'd you like your credit to be? As everybody writes now, based on this particle. I just wondering. I just
nobody says Esquire.
Sure.
You know what? Can we digress for just a second?
You're
as
an
attorney.
Okay.
Yeah, right. But as an attorney, I have never once signed my name. Dave
Is that
Wilms,
what that means?
David Wilms,
I had no
Esquire.
idea.
That's what. I don't actually really know.
Well, we could postulate then.
But it's
let's pretend like we
anybody
know
that's an
what we're
attorney
talking about.
could theoretically sign it as Esquire. But why? Why? If you're listening out there and you're an attorney, I would like, and you sign your name, if your signature block
would you quit listening to
has
our
your name,
podcast?
Esquire, would you write in and no. Would you write in and explain why you do that? I've never understood it.
Yeah.
It just, I don't know.
Well, I think the best part about this for me is I
don't know.
As a non-attorney, I can't
even explain
about
what
all
it-
these laws.
why I
and
don't do
never
it. I
have
just
to worry about being
feels
so
wrong.
wrong that people that I get disbarred.
Yeah, I guess I have to do that.
This is
I
not
should put a
legal
big
advice.
asterisk on this.
Yes.
Don't rely
and for
on
me,
anything
because
I've said
I
here
don't want to
today.
practice law
It's
without
not legal
license.
advice. Yeah.
Everything I
don't
say
turn me
is
into
like,
the bar.
You know what I think? There you go. Yeah.
Right. Anyway, we will come back to this. I know we're going to be really revisiting this topic in future podcasts. If you have questions about it, reach out to us. We're already fielding questions about this, and we're happy to answer questions. So if you have questions about this Herrera case and what does it mean for you, what does it mean outside of Wyoming, send us an email at yourmountain@itsyourmountain.com. Let us know. Ask us any questions.
I have
you
one
got.
more
We're happy
thing to
answer.
share because this is a
Nephi,
podcast.
you're
So
looking
if
at
you
me
listen to our
all
podcast,
inquisitively.
you all know that our gun giveaway is over. You better check your email, buddy. And I'm not going to say your name.
Did we?
But the person who won the gun giveaway is not responding to email. So go look at your email.
Oh man.
Well, that will be in the.
How much time
that
before
will
we move on
be in
to the
your
next
email.
person?
If you do not respond, and thanks again to all of our partners on that. Thank you to Gunworks. Thank you to Vortex Optics. Thank you to Wyoming Arms. Thank you to Proof Research. Thank you to Viking Tactics. Timney Triggers. Thank you to Federal Premium Ammunition.
Timney Triggers.
For everyone who, thank you to Magpul, for everyone who participated in that. We will announce very shortly, or we're going to let you all know that thanks to somebody not checking their email, you got a second chance.
We'll just draw again if we have to. Yeah.
Check your email.
We're going to announce
Check
a winner
your
just
email.
as soon as we can locate one. Yeah, so check your email.
Yes.
Yeah, we're excited to be able to give this away. We want somebody to win this thing, right? All right. And one last note, because we have to include this. I have to get this in every podcast, right? I just feel like I have to. You are listening to this for some reason, and we thank you for listening to this. If you haven't done so already, please, 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 please go out there to wherever you get this and give us a rating. Leave us a comment on the place you get this podcast from. That stuff.
Feed our egos.
Those two things.
And keep us doing this, because this is the only way.
They keep us doing it. It's what keeps us going. If you're liking this content, help us out by providing us that kind of feedback. That's the type of thing that'll make us want to keep doing it. If we don't hear from anybody,
let's not kid ourselves.
We'll probably still keep doing this.
Have it now. All right.
Yeah, but no, we'd appreciate that. And I'll tell you this: like I was looking at our iTunes the other day, and we just need like 4 more people to go out there real fast and give us that 5-star rating. 4 more people, so we can bump up into our next threshold. Right. That's what I want to see us happen.
Just the next 4 people that go and give us a rating, we're going to send out 4 hats. I've got hats. I'm not telling you which company, but
we don't
you're going
have
to
any
get some cool
hats.
hats. No. Never worn. Yeah, I'm going to give away 4 hats.
Is that really what you're doing?
The next 4.
All right. So we need to have
comments,
that's more than a rating. We need to have 4 comments to do that, right?
Hat.
Next 4 comments on iTunes.
Take a screenshot.
You got to send us an email. Send us an email. Take a screenshot and send us an email of that comment so we know it's you, so we can get it to you.
Right.
Our email is yourmountain@itsyourmountain.com.
My wife
Nephi
thanks
is
you
a
for
hat
taking
aficionado, so you're probably going to get a good one.
There will not be worn. There will be unworn hats, just so we're clear. All right.
I imagine that's probably true. You have a lot of hats. Anyway, so that's where we're going to leave it here. Shoot us emails if you have other podcast ideas. And a reminder, the sky is not falling in this Herrera v. Wyoming saga, but we'll continue to keep you updated as things develop in the coming months and years. And as always, remember that life is about experiences, so go have them.